Welcome back to the Law Newz Network, everybody. I'm A-aron Keller. We, of course, saw both of our trials end in pretty quick succession there. The Bella Bond case appears to have wrapped up for the day, so that continues in Boston. That, of course, is the case involving the 2-year-old child found dead in Boston Harbor. We also saw the case just end in the Michelle Carter situation, also out of Massachusetts. And Ken Belkin is here to discuss the ramifications of what clearly is his favorite case, the Carter case. And we're here to discuss them on what is an oppressively hot and humid day here in Midtown Manhattan. So
very hot.
Thank you for
wearing 2 pieces today instead of 3.
Yeah, I was going to say that's dressing down for you. I mean, I'm under strict orders to not look too spiffy, but those orders don't roll out to you. And in case nobody's noticed, the linen is out because I don't want to pass out when I walk home. So anyway, the Michelle Carter case is an interesting legal case, as we were talking, because I think, and you correct me if I'm wrong, that it's a case that revolves around law much more than it revolves around fact. I mean, the facts are pretty indisputable here. They're text messages. There are internet searches. It's not like it's a he said, she said, where a fact finder really has to whittle out exactly what happened. We know what happened. It's just a question of whether the law attaches to it.
Yeah, I mean, it's going to be a question of whether the judge interprets the harm in this case to be created by Miss Carter, and if that harm, if those text messages constitute harm enough to cause this man to take his life, which, as you know, I think is a stretch.
I just got word of something in the Dippolito court, which is still in session. I wanted to, we thought it may have been a witness who it turned out not to be, but I couldn't see it anywhere in here, so forgive me, I tuned out for a second while I was listening. We were talking about the law versus fact, so
it's really going to boil down to whether or not those text messages constitute the harm that caused him to take his life, and I don't think so. I think this is a guy, he's had 4 prior suicide attempts. He had a Google search history of trying to figure out ways to commit suicide, and I just don't see how her text messages didn't put him in the position to kill himself. He put himself in that position. He didn't asphyxiate on text messages, he asphyxiated on carbon monoxide.
That's prepped all for the argument in the next trial that you have to put together on this matter. So, the facts are an issue of characterization, but then it's like, okay, well, where do we go from them? And just to be clear, the audience watching this case at home is virtually unanimous that they think this should be a conviction. It's those of us sitting in here who really seem to be on the fence about it here. And I keep getting stuck on this issue involving whether she had conduct or whether it was mere words. At least that's what I'm sticking on. Do the words or the text messages count as conduct under the law as it's written in Massachusetts? There has to be intentional conduct. Well, we know that there was something intentional. I mean, she apparently intended to transmit her thoughts to him. But, does this count as conduct where it would have traditionally been looked at as speech?
I mean, certainly it might be conduct, the act of sending the message, but, did that conduct result in him taking his life? And I think it's really, his conduct supersedes any causation that could be put at her feet. Her text messages were repugnant. This man was undergoing some deep emotional turmoil, and no one's defending her text messages. But what you have to do is you have to leave the emotions aside. I don't believe that text messages kill. Carbon monoxide kills. She did text, "I love you, kill yourself." Well, if I had a quarter for every time an ex-girlfriend texted me that, I would probably be giving up my law practice.
You must have dated many more people than I have in that process. But what's the song? Here's a quarter called "Someone Who Cares." It just came to mind. But anyway, so the Supreme Judicial Court looked at this issue once, and I thought that even though the opinion is about the grand jury indictment, it seemed to me that the court really drained the water out of the swimming pool on many possible grounds for appeal here. And I know it's a different standard of review when they're reviewing a grand jury indictment over here versus reviewing a verdict on appeal for error over here. But they did say that verbal conduct can overcome a person's willpower to live and therefore be the cause of a suicide. They came out and said that, and to me that just drained the water out of a possibility for appeal on that issue.
Look, I mean,
so it's an interesting decision, and it still seems like it's pounding a legal square peg into a legal round hole, but it seems to stick with that court because they've held this line of jurisprudence for at least half a century.
Yeah, I mean, my opinion is that the appellate court probably wants it to be resolved at the trial level. They don't want to delve too deep in this. And certainly there are instances where speech could cause harm that takes human life. You know, the classic scenario of don't yell fire in a crowded theater. But this is something much more remote. You're dealing with text messages. The people are not even in the same room.
Yeah, so it's an interesting case for appeal, but I think we're going to go back to the Dippolito case now because they're back live in the courtroom in Florida. So again, this is the case of the woman accused of hiring a hitman for her husband at the time who turned out to be an undercover